The judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
Korn versus Guilotta.
Ready in the court, please.
Mr. Farrell.
Good afternoon, Judge Wackler, Honorable Associate Judges. At the outset, Judge Wackler, I would like, if the court would indulge me, a few minutes taken away from my time of presentation, the opportunity of a reply.
Certainly, if you find that's necessary.
Thank you, Your Honor. Your Honor and members of the court, I am George Farrell. To my left is Edward O'Brien, the County Attorney of the County of Nassau. We are here this afternoon on a matter which, if you do not mind, I have euphemistically referred to as a mandamus of a press release. The primary issue in this case is whether a justiciable issue was presented to Judge DiPaolo, upon which he rendered the two judgments from which this appeal was taken. The appellant strongly urges that there was not. The principal case that we are relying on is that of Saxton v. Carey. This case, decided in 1978, stated in part as follows at page 548. Appellants argue quite properly that it is the responsibility of this court to apply and enforce the will of the people as expressed in our Constitution, even if this results in considerable practical difficulty. And they urge that no branch of government may avoid the mandate of the Constitution. From this, they would have us conclude that it is a proper function of the courts to police the degree of itemization necessary in the state budget.
Well, we do have a situation, Mr. Farrell, do we not, where we have a mandate within the county charter.
That's correct.
Under 3025, which says that the full surplus should be announced in the budget. Now, the court is confronted with the fact that this was not the case, and so the court takes action.
Your Honor, the word full that you just used and was used in the decision of Judge DiPaolo and affirmed by the Appellate Division is not found in Section 302.5 of the Charter of Nassau County.
Well, it need not be. A surplus is a surplus. A full surplus isn't any more than a surplus, is it?
Your Honor, if I may, I understand that the direction in which you are going, but I'd just like to, I will answer your question immediately, but I would just like to point out in the Hidley case, and I understand that was a dissenting opinion, and I'd like, if I may, to paraphrase from that decision. But the decision is worded as follows. There is a constitutional mandate to itemize. And in this case, I would like to emphasize that what I'm really emphasizing here is that to use the word interchangeably between itemize and estimate. There is no constitutional definition of itemization. There is no judicial definition of itemization, and no inflexible definition is possible.
Well, I think your argument is that we're interposing our estimates in place of your client's estimates, but we're not using any estimate of our own. We're using figures that he himself used in the newspaper and in his budget message.
And the difficulty, Your Honor, with that, and the pitfall that occurred in the lower court and again in the Appellate Division was a total misunderstanding of what surplus is. First of all, only beginning in or about the 1970s were local governments in this state required to go on a modified accrual basis of accounting. This to be done according to generally accepted accounting procedures. The effect of that is that the final closing of the books for all governments in the state does not occur until sometime in the month of February in the year succeeding the budget.
Well, Mr. Farrell, we may not know particularly what surplus means, but we do know what your client thought that surplus meant when he announced on the 26th of October, 1987, that there was an $80.1 million surplus.
There was an estimate of the amount of cash that he believed would be on hand at the end of the fiscal year, an amount unable to be determined until the middle of February of 1988.
Well, he did use the word surplus, did he not?
He did. But the charter refers to cash on hand. Cash on hand is what you have in your hands. The cash that was actually on hand in the county of Nassau on 12/31/87 is different from what the surplus was at the middle of February or the end of the 13th month.
And that brings me to your characterization, Mr. Farrell, of the fiscal year as running to February. Do I misunderstand you?
Yes, Your
Does the charter provide for the fiscal year to be coterminous with the calendar year?
Technically, the fiscal year terminates on 12/31 of each year. But because of your being on an accrual method of accounting, which means that anything you were entitled to receive up till 12/31, whether you received it or not, is income or revenue, and any obligation that you've incurred, even if you haven't been billed for it, is an obligation of that year. So if a vehicle is purchased in the final or delivered in the final months of December in any year, and the bill isn't rendered until the middle of January of the succeeding year, it's still a liability of the prior fiscal year. And so every municipality in the state of New York uses, in a sense, two sets of books for about the first 2 months of each year, debiting and crediting against, in this case, the 87 fiscal year on the one hand, and dealing with the 88 fiscal year on those matters which were properly 1988 matters.
And is it in that month that the $80 million surplus became $17 million?
The $80 million, let me just say this to you. There was no surplus after 12/31/87 on an accounting basis. And the reason for it is quite simple. The county executive put a number of $17.7 million in his proposed budget on the line 3025. And by the way, I might say parenthetically, there's a big difference between mandating that someone fill in a blank and the court saying, we don't like your number. The legislature, after public hearings and an analysis of the budget, increased the 17.7 to 20.2. Now, there were a lot of things happening at this period of time that rendered the estimates very difficult. You had the October 19th incident in Wall Street. There were great doubts about what was going to happen with respect to the sale of hard and soft goods in the final quarter of 1987. Projections with regard to revenues were difficult to make. And keep in mind that Mr. Guilotta prepared this budget a week or two after that incident in October in order to deliver it on the second Monday of November, or before that, to the legislature. They were also advised, although they didn't know the precise dollar amount, that a substantial increase in the premiums for Blue Cross Blue Shield for state workers was imminent. As it turned out, and is before the record, or in the record, excuse me, that amounted to $20 million. Now, what happened here? There may or there may not have been $80 million. We'd be here all day trying to figure out how much there was. Very simply, what happened here was the only cash from an accounting point of view that was available was the $20.2 million.
The thing that's confusing me, Mr. Farrell, is that the budget that was proposed by the county executive, as I understand it, and perhaps I'm factually wrong, when he proposed his county budget and sent a covering letter with it, he said in the covering letter that there was an $80 million surplus, but he only budgeted $17 million.
What he said, Your Honor, was that I am putting cash on hand estimate of 17.7, and whatever the difference is, after the sales tax is determined, after we know how much we actually owe for the Blue Cross and Blue Shield, whatever the balance is, we will put it into a tax stabilization fund. And I think this is the heart.
Did not his submission to the county legislature say there was an $80 million surplus?
That was his estimate.
Well, then wasn't he obliged to put that in his proposed budget?
No, Your Honor, he was not.
Well, he just left it off the books indefinitely.
First of all, Your Honor, surplus, as a technical term, does not occur until you determine exactly what the number is. It isn't surplus until February of '88.
But then the county charter requirement would be meaningless. Any number could be put in there, and you'd say that complies.
In a sense, that is correct, as long as all other funds that were there to be accounted for were accounted for. There are no hidden funds here, Your Honor.
What was the use of a surplus, if any, for the establishment of a stabilization fund, as was proposed here, authorized?
Absolutely, Your Honor. And this is given recognition to in the decision by Judge DiPaolo.
When was it authorized?
It was an act of the county legislature in February of 1988.
Not at the time the budget was adopted, though.
No, Your Honor, but it was still at the point where the 1987 budget fiscal year had not been closed out.
Does that apply to all of the difference or only part?
It's all of the difference, Your Honor, because the only monies that were available at the end of the fiscal year, which is the only time when surplus could be determined with exactness, was the amount of money that was put in on the line 3025, $20.2 million, and the $24.5 million that was put into the tax stabilization fund, and that was the final act of this legislative body and the county executive for fiscal year 1987. It was acknowledged as a supplemental appropriation for the year 1987, not 1988. And since it was appropriated in 87, it had no business being in the 88 budget.
And that appropriation equals the total difference between the 80 million and the 17.5.
No, Your Honor, but I'd have to have 2 days to go through with you what happened to the 80 million, because remember, it was an estimate. How much revenue was going to come in from sales tax? How much revenue was going to come in from fees? How much revenue was going to come in from fines and so forth? That was in the estimate.
So that's part of the difference between the 80 and the 17.5, which is not covered by an appropriation for the tax stabilization reserve funds. Is that so?
Well, yes, Your Honor, in this sense. Let me just say this briefly, and I'm running short of time.
Do you want to reserve 5 minutes, Mr. Farrell? Is that it?
3 minutes, if I may. There was the $24.5 million that went in the tax stabilization fund. There was the $20.2 million that was in the budget on 3025. There was $6.9 million of 1262 tax money. This was sales tax money that had been generated in the towns of Nassau County that dealt with matters for which exemptions were given by the city of Glen Cove and the city of Long Beach. That money could only be distributed to the towns outside of Glen Cove and Long Beach. That's 6.9. Also in the $80 million was a $17 million estimate of the surplus for 1262D money for 1987. So there's $26 million plus 24 million is 50 million, plus the 20.2 million is $70.2 million. Now, as I said, I could stand here, and here's the budget, 832 pages, thousands of line items in it, and they all are subject to pluses and minuses between the period of time of the estimate and the end of the 13th month. This is not a simple matter. It's very difficult to understand.
But isn't, following up on your last statement, Mr. Farrell, if these are estimates that are in the budget, subject to pluses or minuses up to the end of the 13th month, why isn't there some provision in this budget for that excess money that is not already accounted for? It's a subject of this litigation.
Because, Your Honor, it was all taken care of when the legislature created the Tax Stabilization Fund, and thereafter, as the last act of 1987 fiscal year, transferred whatever money was left from 1987 to the Tax Stabilization Fund.
Wasn't there a letter that was appended to the budget to the supervisors, which said that there was a proposed that 24.6 million of the surplus should be expended in 1988, and the remaining 56 million should be saved to reduce taxes in 89 and 90. What was that letter about?
Your Honor?
Obviously, there was a surplus in his mind at that time.
Your Honor, what he was saying is, I am taking so much of what I estimate will be on hand and putting it in 87,
No,
and the rest I'm putting in the Tax Stabilization Fund. And he was wrong. It wasn't 56 million, it was 24 million, and that's our problem.
he says it should be expended in 88, and the remaining 56 million, doesn't say the remaining estimated 56 million.
You may respond, Mr. Farrell.
Well, Your Honor, it only proves what I've been trying to say. In October of 87, with all the vagaries that were going to occur between then and February of 88, no one really knew what the number was. They were estimating what the number was. It's something that is impossible of definition.
Thank you, Mr. Farrell.
Thank you.
Mr. Beal? Mr. Beal, there's something that concerns me at the outset, and perhaps you can set my mind at ease.
Yes, sir.
There was no secret about what Mr. Guilotta was going to do here. It was announced, and we've heard reference made to the cover letter. It was in the budget. There was no objection made at the time. Mr. Korn did not attend the budget hearing to protest this procedure at all. Is that correct?
Well, it's not in the record. He has attended. He did not speak at the hearings, but he did not speak at the hearing to say.
All right, now he comes into court, and by virtue of the conversion, we see Section 51 being invoked, which is the exercise of equitable rights or equitable relief. Now, one of the maxims of equity is that if you've slept on your rights, you can't later come in and complain. So not having sought an injunction or not having sought to remedy the so-called defect at the time he was alerted to it, the question is whether he can now come in afterwards to seek equitable relief. And the second part of the question is this: is equitable relief available to someone when the alleged or the claimed error has been rectified by subsequent action? Because equity, of course, is there to put people back to a position where the illegality is dissipated. If there is no illegality at present, and if we have a complainant who did not exercise prerogatives earlier, is he entitled to the extraordinary relief under Section 51?
Well, let me respond to that in a series of statements. The first of all is the first claim is for, under Article 78, for an injunction under Article 78 for failure to carry out a duty obliged that you have to by statute, imposed by statute. Nobody can waive that duty. Mr. Korn couldn't waive it by standing up there and saying, hey, guys, you didn't put, if Mr. Korn had attended the hearing and said, hey, you've omitted $62 million from the budget, and they said, yes, we know we're doing that, but we're going ahead anyway, that would not obviate the illegality.
But this is not an Article 78 proceeding.
Well, yes, it is. The challenge to the proposed budget is an Article 78 proceeding. In fact, there are now two proceedings. An Article 78 proceeding challenging the proposed budget, which was declared invalid because of the omission of the $62.4 million. The second proceeding is a Section 51 proceeding declaring the budget as adopted invalid because the basic proposed budget was invalid and the $62 million was missing. So you have the dual action here. And nothing Mr. Korn could have said at these hearings would make any difference. The statutory duty can't be waived by Mr. Korn, it can't be waived by the legislature, it can't be waived by the county executive. It's imposed by the New York State Legislature and the county charter. Nobody can waive it. And as for the question about whether the illegality has been cured, the answer to that is it hasn't. There was, in February of '88, a $25 million purported appropriation to a 6E fund. But that's $25 million out of $62 million. I don't think the February resolution is in fact a valid appropriation. The court doesn't have to get into that. What you should look at is the situation that confronted the county executive in November of '87.
Can I stop you just 1 minute? Would you concede at this point or not that a 6C fund could be used for deferred tax reductions?
Absolutely, provided.
You would concede that?
Sure, if provided they do it for the reasons.
6C talks in terms of sinking funds for capital improvements
I was
and
just going
things
to say
like
that.
that.
Provided they use it for the purposes set forth in the statute, the home relief, acquiring equipment, and whatever, you can take surplus funds and put them into a 6E fund. County could have done that in this budget. It could have put it into the budget, which would have been appropriate, or it could have done it at the time when the county executive proposed the budget in November, said, we have some extra funds, let's create a 6E fund, let's do it now. So it's not technically, I did misspeak, it's not technically tax reduction funds, and that's what Judge DePaola pointed out, but it has that effect, because if you take $25 million and put it off to use for capital equipment, you don't have to use tax funds.
Had they done the latter, how would it then appear, or how should it appear in the proposed budget?
Well, the proposed budget, the item that said a fund balance beginning of year should say $80.1 million. And then on the appropriation side, there's an appropriation for tax stabilization fund under 6E. If there are healthcare premium increases, there's an appropriation for that. If there's money that has to be held aside for other purposes, it's all put in the appropriations. The purpose here is to put it all on the record. Let the people of the county see how much money there is, and let them see what the county officials want to do about it. Let the discussion at the public hearing be an honest and open one, because all the money is there.
Mr. Beal, where precisely in the law is it required that that number have been 80 million?
The number says, the law says you have to put the estimate in. The county...
The estimate...
Of the unencumbered cash balance.
But that's
year-end.
after net of expenses.
That's right, net of commitments, right.
Net of commitments, yet the $80 million, do we know for certain that that was net of commitments?
Well, we have two public statements by the county executive saying our surplus or our cash balance is $80 million, and it's all available, he said, in both public statements, in the budget message and the prior press release, all available to be spent this year, but he didn't. We also have the memorandum, the worksheet of the budget director, which was submitted below by the county. It's at Respondents' Appendix 27 and 28, which is the calculation of that estimate, and it says there, total estimated surplus, $80.1 million.
Should they be accorded the kind of certitude that I hear being presented with respect to something like an estimate in the county charter requirement? One of the things that I'm still a bit confused about is where the magic of the $80.1 million comes from, because a press release and even a cover letter are not, I would assume, the legal documents with which a budget process in a county charter or even the division of budget in the state budget should be governed by in law and in separation of powers problems.
What you have here is a determination by the county executive that this is the number. We have evidence and these are pieces of evidence that show that that was the determination. What the county executive is then doing, it's a bit of a roundabout answer, but you'll see why I'm saying it.
And while you're answering it in a roundabout way, more directly, would you explain to me whether the cover letter and the press release have anything to do with county charter requirements? Are they part of the budget legally?
Yes, the budget message, which is the letter that Judge Titone referred to, is required under the county charter. I think it's section 303, but it is required to be submitted with the budget, a descriptive analysis of the budget together with proposed appropriations. What you have here is the county, there's really no factual dispute. The county executive made that estimate, and these are evidence of that estimate. What the county executive is saying here is that he then is free to ignore that estimate and come up with another estimate, that he can simply take this $62 million and say, gee, I really want to spend them in something else, I'll hold it aside. You will never have, there's no document with no requirement of the county charter that says that the county executive has to make an estimate and publish that estimate in a separate document. It's supposed to go into the county charter.
Doesn't the revelation of the estimate in the covering letter, the budget letter, bring to the table the fact that there is likely to be this money, and doesn't the letter indicate the commitment to which that money will be put, so that there's nothing hidden, there's no secret, there are no secrets in the budget process?
Well, I don't think that's so, because I think what you have here is a fairly vague statement of what he wanted to use the money for. It's not detailed in any sense. The Board of Supervisors never appropriate that, never approve that budget message, never formally say, yes, we'll only put 20 or 17 or 20 million in the budget, and yes, we will take the other 54 or 62 million dollars and put it elsewhere. Without that formal action by the Board of Supervisors, you basically are left with the whim of the county executive. He has the desire to put $60 million into a tax stabilization fund. At that point, it's no more than a twinkle in his eye, and he's saying that twinkle enables him to hold $62 million off budget.
And you say the fact that at some later time, that twinkle developed into an ordinance and a commitment doesn't help the situation.
Well, not after the end of the fiscal year. It was in February of the next year. You see, there's a confusion in Mr. Farrell's argument between budgeting, which is done in advance, based entirely on estimates. That's what the statute says, estimates. If you're wrong, then there are ways of correcting it, but the budget is always done on estimates. Accounting principles take place after the end of the year. That's when you close the books. That's when you deal with actual numbers. We're dealing with a budget here. We're not dealing with accounting. This is controlled by statute, which says estimates in advance before you spend any money, not accounting principles. After the year is over, you can kind of fix up the books and let $62 million disappear after the year is closed.
Just one last question before you sit down, please. You indicated that the Article 78 proceeding is still viable. That wasn't dismissed as being moot?
No, no, it was not. It was the...
You took no appeal, did you, from Judge DiPaolo's conversion and his disallowing the Article 78? I believe he stated that Article 78 would not lie.
No, he said Article 78 lies to challenge the proposed budget, but it does not, and granted, and then he said, but it does not lie to challenge the budget as adopted. So he converted the action into two. One, against the county executive solely under the proposed budget, and the second, that's the Article 78. The second is the Section 51 action against all the...
You took no appeal from
No, that, I think the judge actually was correct in making that, in splitting the action into two actions. And he can do that under CPLR 103.
And then he did not make any determination under the Article 78?
Yes, he granted judgment under both. He entered two judgments.
I thought he said that it was moot.
No, he didn't. I have the appendix here. There are two judgments. One, the judgment into the Article 78 proceeding is on page A14 of appellant's appendix, and the judgment in the declaratory judgment action is at A11.
And is it clear that the appeal is taken from both?
Yes, absolutely, all proceedings at once.
Thank you very much, Mr.
You're welcome, thank you.
Mr. Farrell.
Thank you. I'll be very brief, I hope. First of all, let me address the $80.1 million, which in the dialogue, council has indicated belong on line 3025. And let's understand what that line imports. The number that goes on that line, which in this case, the real number is 20.2, is revenue for the upcoming budget year, and the effect of putting it on that line reduces the real property taxes in the 1988 fiscal year to the extent of that dollar amount. Now, when council says just put $80 million on that line, what you're doing immediately is reducing the revenue from real property taxes, and if you're wrong, you have a sizable deficit immediately. And in this case, look what the numbers were. And by the way, all these numbers were before Judge DiPaolo. This isn't information that developed on appeal. If you read his decision, if you look at his judgment, he acknowledges the receipt of all of this information. The true number for 1988 was not 80.1 million. It was 44.7. Where would we be today if we followed Mr. Beal's advice and Mr. Korn's advice of putting $80.1 million on that line? We'd have a $36 million deficit right here this moment. And that's why this estimate has to be a very conservative number. That's why surplus doesn't become surplus until you close your books, because you really don't know what you're dealing with.
I don't think anyone is quarreling with the county executive's right to make his estimates conservative. I think they're quarreling with the action he took in keeping what, by his own figures, was $60 million off the books.
Your Honor, I've tried to explain to you, 17 million of that is 1262D money.
I know, I've heard your...
6.9 million is 1262D money. 24.5 million went into the tax stabilization fund, and there wasn't any other money.
My only response is, why didn't he identify that problem with the budget submission instead of using an inconsistent set of figures then?
Because, Your Honor, he received advice...
One would think it was an argument that was developed when the litigation started.
He received advice, and I think sound advice, from his budget director of 17 years. He has an elected comptroller who submitted an affidavit of regularity to the lower courts. And they counseled their accountants. And this was all done according to sound fiscal procedure. What we're responding to today isn't a statement made by one of the big 8 firms saying, this is ridiculous accounting that goes on here. This is Mr. Korn's idea of what the accounting should be.
Are you implying that the $80.1 million figure in the budget message was a mistake in judgment, though, because it was inconsistent with the amount that was on line, whatever it is?
Your Honor, to the extent that one can be charged with a mistake of judgment in making an estimate, perhaps you're right. But to me, if you're going to make a mistake in judgment, it's when you say, this is it, this is the law, these are the facts. But when someone says, I really don't know what they're going to be, but this is my best estimate, I think that's the only way that I could view that.
Thank you very much.
Thank you very much.
Matter of Westchester County Medical Center versus Hall.
Ready.
Scott, just initially one question. The decisions below, both of them seem to start with the concession that the patient was incompetent here. Was that the product of, as you read this, and I really don't know the answer to this, a determination, a factual determination, or was it a concession as between attorneys based on what they believe the condition to be?
Your Honor, I think it's a factual determination. The doctors, more or less, as a result of her strokes and everything. That's what
Incompetent to make a determination on her own.
Yes, Your Honor. Yes, Your Honor. May it please the Court, my name is Carol Van Scoik, and I'm an Assistant Westchester County Attorney with the Westchester County Attorney's Office and represent the appellant, the Westchester County Medical Center. 7 years ago, this Court decided in matter of Storer, rejected the substituted judgment doctrine in favor of a rule that individual self-determination must decide questions of when and under what circumstances medical treatment will be withdrawn or withheld from incompetent patients.
Well, let's argue that this is not substituted judgment. This is merely using the judgment which she exercised when she was competent enough to exercise judgment.
Your Honor, the key to this case is basically specificity. That there was nothing, no one could interpret, first of all, what she meant, because no one knew what she meant. She never really explained what she meant by artificial life support.
Well, she didn't draw a diagram, but she meant that she didn't want to be kept alive artificially. She didn't want to be a burden.
But, Your Honor, it's not clear as to what she meant.
If we were dealing here with a respirator instead of feeding tubes, would the result in this case be different as far as your position is concerned?
See, Your Honor, a question like that just points to the whole problem with the lack of specificity, and which is what was required by this Court in matter of Storer. Without that specificity, then all we can do is speculate.
Do you say that it's necessary to specify feeding tubes in order for a patient to express her desire?
To avoid speculation, Your Honor, that's the most important
Would
thing.
you say
It's
she would have
important.
to list every single item of artificial sustenance and for it to be good? She would have to say no feeding tubes, no intravenous, no oxygen, no resuscitation, no... She would have to put all that.
See, Your Honor, it would have to be to avoid speculation. I know it's a great burden, but to avoid speculation.
So in other words,
we're dealing
you would
with
say
someone's
that
life.
no matter what it was, she would have to put down every single item.
Not to lead to speculation.
There isn't any speculation here. There's a finding of fact that she didn't want to continue living if she was in this condition. She didn't have to say, I don't care whether you can keep me alive by a respirator or you can keep me alive by a nasal tube. She didn't want to stay alive.
But
What's the speculation? That's found with the trial court and affirmed by the appellate division.
But as a matter of law, there's no...
That's the Eichner test. This comes within the Eichner test. What you're talking about is changing the Eichner test, are you not?
But, Your Honor, specifically in the Eichner decision, the court specifically stated there was, of course, no need to speculate as to whether Brother Fox would want this particular medical procedure to be discontinued under these circumstances. The test seems to be a strict test. In that case, Brother Fox had just 2 months before when he became incompetent, reaffirmed his position that he did not want to be maintained on a respirator. Now, in that case, there was much publicity about Carolyn and Quinlan. He had formal discussions with his religious order. He had strong religious reviews on this case.
But that case was decided with the Storer case, and the distinction drawn between the two cases was one was self-determination and not substituted judgment. In the Storer case, Mr. Storer had no idea what the treatment was or might be in the future, but that was not determinative of the case. It was determinative there that he could not express his own determination of what he wanted done with his body.
But, Your Honor, part of self-determination is the ability to have consent. And if you're not aware of all the risks and alternatives that one is facing, how can you really have consent?
The person doesn't want to lay in a hospital room indefinitely, unconscious, with tubes coming out of every orifice of their body. They don't care whether it takes a respirator or whether it takes dialysis or oxygen or anything else. By and large, don't you think that most people say, I don't care what it takes to keep me going. I don't want to live that way if I'm non-compass menace and can't understand what's happening to me.
But,
and
Your
have
Honor,
no hope of recovery.
but the test is a very, very subjective test.
There is no yes, it's subjective.
And it's what this particular individual would want under these particular circumstances.
Well, she made that known, though, did she not? Aren't you putting an impossible burden on a lay person?
No, Your Honor, it's not an impossible burden because we're dealing with a life. And unless we're very sure and we're not speculating as to what type of treatment she would want under the circumstances, and that was never made clear, no one could tell.
By your formulation, if one particular type of treatment was specified, then any other life-sustaining support could be applied.
But, Your Honor, we would be speculating. If one particular, as in with Brother Fox, he said he did not want to be maintained by a respirator. So there was no need to speculate in that case. But then we would have problems with speculating, especially with basic care, what was presumed to be basic care.
If you're requiring specificity, and the patient specifies a particular life support, then it would be only that life support that could be discontinued under your formulation. All other supports, no matter how offensive to the person, would remain in place.
But if someone would, as in the DeLeo case, if someone was specific as to their particular decisions on something, they would probably mention several types of,
Why isn't the court properly entitled to make a decision that based upon the language she used, based upon the problems that she was confronted with in caring for her husband or brothers or stepmother and everything else, based upon her knowledge as a nurse, why isn't the court entitled to interpret her remarks as, I don't want any?
Your Honor, she was not a nurse. She was an admitting clerk at a hospital.
She worked in a hospital. She saw things happen, and didn't she express a desire to avoid the use of artificial means to keep her life going?
But she never elaborated upon that. Artificial means were never...
Artificial means, putting a tube down one's nose isn't feeding the person pesto, you know.
But up until last year, the DeLeo case was the first case where a New York appellate court made a determination that food and water were considered to be artificial means.
It was not a radical decision. It was the same decision the President's Commission, the American Medical Association, and most of the courts of this country came to.
But be it that it may, Your Honor, still under these circumstances, we're dealing with an individual, and it's a subjective test, and there's nothing to indicate that Mrs. O'Connor would have refused, wanted, or didn't want a feeding tube or basic care. That was...
As you read the New York cases, is the subjective test the only test in New York as opposed to, let's say, New Jersey, which has a modified objective and an objective test?
Yes, Your Honor. We have the basis of New York's decision is matter of Storer, and matter of Storer is a subjective test. I know New Jersey has adopted an objective as well as a limited objective and a subjective test plus best interest and other things.
So the sole issue in this appeal then pertains to the adequacy of the proof under the so-called subjective test.
And specifically specificity as a matter of law.
Thank you.
Well, assuming that she had expressed her wishes not to have any extraordinary means and satisfied even your specificity test, let's assume that that's the law. Did she express that on this record in such a way to satisfy by a clear and convincing standard that that was to be so under any and all circumstances at whatever temporal point in her relevant medical condition that might occur? In other words, does it depend on whether she's in a vegetative state, what her particular condition is at a particular time as certified by a particular doctor? Is there anything in the record with respect to that?
She never discussed what specific circumstances in terms of what condition that she was to be under, whether it was a
She said she didn't want to be a burden.
Right,
She didn't want an artificial life support.
But that's very vague, because what is meant by that? A burden? Her daughters took care of her for 2 years when she wasn't able to take care of herself, from 1985 to 1987. So what does that really mean?
Well, she said more than that. She said she didn't want her life maintained by artificial means, by machines, which is precisely what's now being proposed, is it not?
The only thing, when her daughters were asked to explain some of the conversations that they had and everything, they weren't able to relate anything that she said specifically about artificial life support systems. There was a conversation back in 1969 with Mr. Lampasso where they had a discussion, and she said something very vague like machines, but it was very vague. And back in '69, Who knew about food
Well,
feeding
that's
tubes?
just it. I go back to Judge Kaye's question about imposing an impossible burden then, because first of all, a layman would have to be able to know and think of every conceivable type of life support system, and then on top of it, under your test, he would anticipate what future developments there might be 10 or 15 years from now in medical science, and nullify them too. I mean, you almost have to write a contract. I don't want anything today, anything that could possibly be developed, including A, B, C, D. Isn't that about what you're asking?
I know it's a tremendous burden, but in
It's
the absence
impossible
of
burden. It
legislation
couldn't be
for living
fulfilled,
wills,
could it? It couldn't be fulfilled, could it?
it has been fulfilled under the matter of Storr, matter of Eichner test. There was a perfect example. And there's no doubt, there was no need to speculate, because Brother Fox had discussed a respirator.
If she was fortunate enough to have read the D'Elia case and say, now listen, see, if that happens to me, and if the Quinlan case happens to me, and if the Conroy case happens to me, if any of these cases happen to me, I don't want that, she'd have been all right. And fortunately, Brother Fox had the Quinlan case in front of him. But except for that fortuitous circumstance, how could anyone possibly specify with any degree of certainty that their wishes would be carried out?
Your Honor, it's a tremendous burden, but we're dealing with life and death consequences, and such a burden is required.
What you seem to be suggesting is a very long and detailed and specific form that somebody looking forward to the next 20 or 30 years would have to anticipate, almost a long printed form that took into account every single possible accident or injury that could befall a person and every advance in medical science. And in some ways, if you did succeed in getting such a form, that would be less of an expression of a person's will, would it not, than the simple statement that I don't want to be maintained artificially.
But, Your Honor, the problem is with simple statements and vague statements, do we really know what they mean? When her own daughters were asked to explain what did their mother mean by artificial life supports, they couldn't explain. They didn't know, and they couldn't interpret for her because substituted
But
judgment.
Mrs. O'Connor was pretty consistent about this. She said in '67 when her husband died, she said in '69 to a friend, after a friend's father died, she said in '73 or '74, she said in '84, she said it in '85. It's not something that she said once and somebody's trying to hang their hat on. She was pretty consistent that she didn't want to be a burden on anyone, and she didn't want any artificial life support.
But as Judge Brown pointed out in his dissent, many of her reactions were basically to deaths and everything. They weren't solemn pronouncements.
When would the conversation come up, really?
Really, as a result.
Let's be realistic. When would it come up? I mean, it wouldn't come up if you were, just sitting there having dinner or watching a ball game. It would normally come up after someone's death, and she would say, I would never want to go through that. I don't want any artificial life support.
But many times, that's just an emotional reaction to the situation.
The whole thing
It doesn't
of death is
necessarily.
emotional. If you're going to take emotion out of it, another one, if we're going to make that a test also, then we'd never be able to have it, would we?
But under the facts of this situation, granted, there is a burden here, but when general statements are made about, I don't want artificial life support, and you can't explain it.
Given the fact that you have the affirmed findings below, is it an appropriate role for this court now, and can we say on this record, as a matter of law, that the evidence of her desire was not clearly and convincingly established such that we would reverse the appellate division?
Your Honor, as a matter of law, we're saying specificity should be required. It was required in matter of Storer.
What does that mean?
Being able to, under specific circumstances and specific medical
Does that mean identify
treatments.
each and every possible means of life support?
That's the only way we can avoid, to the point where we can avoid speculation.
Ms. Koyak, was it made clear in this record that being deprived of food and drink, as would be the case here, necessitates or implicates pain?
Yes, Your Honor. There was two medical experts that testified. Dr. Sivak contends that she will express pain because of the fact she's conscious. This is a conscious person.
And there was no expression in any of her earlier pronouncements with respect to her willingness to suffer or undergo that kind of travail.
Well, there
No,
was
Your Honor.
contrary evidence too. Dr. Wasserman said she would not experience pain, did he not?
Yes, Your Honor, but
And
it
the
seemed
courts made no finding.
it seemed to be that his conviction was rather shaky, because he said if there happened to be pain,
That's
that
the
it could be
analysis you
alleviated by
put up.
painkillers, which
No,
is artificial.
That's the analysis you put upon his testimony. His testimony was she would not experience pain. If he was wrong in his judgment, which he didn't think he was, painkillers were available.
I think the record indicates he wasn't positively sure. None of the doctors could be positively sure that she would experience pain, but one doctor said she would definitely experience pain.
If this case were like the Brophy case, I think it is, in Massachusetts, and the patient was comatose, in a vegetative state, and in a terminal condition, would that make any difference as far as your argument goes?
Your Honor, this is the first case in New York that deals with someone that is conscious. But in terms of self-determination, if her statements had been clear and specific to the point where they wouldn't lead to speculation as to whether she would want food and water under these circumstances, then there wouldn't be...
It would make no difference.
No, Your Honor, because of the
So
principle of
someone-
self-determination.
Someone in a far worse condition than the patient here, absent prior statements made while competent, sufficiently specific, is in a position where nothing can be done.
New York, since New York law, we don't have a best interests test or anything. It's based on self-determination.
But if,
And there would have to be statements made, statements
but
specific
if
enough.
if her condition was much better than this, you have an entirely different set of considerations implicated, don't you? Because then the state's interest in prolonging life or in avoiding suicide to someone who is perfectly healthy comes into play. At least the courts below found it did not come into play in this case because the state has no interest in prolonging a life that is in this condition.
This is the first case that deals with someone that is conscious.
Yeah, I know. I'm responding to your answer to Judge Hancock's case. It does make a difference how bad the patient is, does it not?
In the DeLeo case, they said the condition and an age of the patient were irrelevant, just in terms of self-determination. That's the key.
But in this
But a
case, she's
person
not
doesn't have
suffering
an
from a
absolute
fatal
right.
disease.
She's not suffering from a fatal disease in this case. No, there's no terminal illness.
So
And
she was conscious and not suffering from a disease which will bring about her death, at least not imminently or that anyone can determine with any medical certainty, which makes it very different in terms of the implicating the state's interest in prolonging and protecting life, does it not?
Yes, it does, Your Honor.
But if...
Her condition now is exactly what it will be, or her condition will be for the foreseeable future, exactly what it is now, will it not? It's irreversible.
Your Honor, I can only venture a guess. I'm not a medical
Well, that's
expert.
what the
but
doctors said.
The
It's
doctors more or less
irreversible.
see that. However, they also have seen an improvement in her condition. The more caloric intake she has, her general overall condition has improved. Granted, she has been incapacitated from the strokes, but if she receives more caloric intake, her general condition is better. She is a responsive person. As Dr. Westerman had testified, the neurologist, he said that 50 to 60% of her responses were intelligible. She's able to say things like her name and all right. She is able to do certain things. There is signs of reaction to stimuli.
Is that an improvement?
It's an improvement in the sense that she's responding better. She can interact somewhat better.
Has anyone ever asked her the question, so far as this record shows now, as to whether she wants this nutrition ended?
At this point now,
Yes.
no, Your Honor, no one has. The questioning that took place at the time, they had came to the decision that she wasn't able to respond to the question.
I am aware of the testimony you mentioned of 50 to 60% responsiveness. Did I understand you to indicate that there is also some evidence that she is improving?
Her general condition is improving, according to the doctors. They say with the more caloric intake, she can react better. She can react to stimuli better. she's not going to recover from her
Her
incapacitation.
mental condition will never change, will it?
Not that they are aware of, no, Your Honor. But as medical certainties, who knows, we really don't know. I just would like to close with, if Mary O'Connor never said whether she wanted or didn't want an IV or a nasogastric feeding tube, which is what happened here, and if she never discussed under what circumstances she wanted any life support to be taken away, which is what happened here, and if her daughters couldn't explain what their mother meant, which was what happened here, then how can the lower court's decision be justified as carrying out her wishes and decisions? When Mrs. O'Connor's daughters were asked what Mrs. O'Connor meant when she said life support, and they said they didn't know, then the lower courts, I submit, were obligated to take them at their word.
Thank you very much, Ms. Skoyak. Mr. Cohen, let's begin where Ms. Skoyak left off. That's quite true with respect to the testimony of the daughters and the friend. They were dealing with terminally ill patients with whom Mrs. O'Connor had dealt. She saw these people fading. She saw these people beyond hope of salvation. She saw these people as a burden, and she said that she wouldn't want to be that kind of a burden. But she never really did say that she would want to undergo whatever pain or discomfort is associated with being taken away from food and water. And indeed, when her daughters asked what her attitude with respect to that would be, they said that she didn't know, or they said that they didn't know. Now, wouldn't that lead us then to a substituted judgment as opposed to acting on the express judgment of Mrs. O'Connor?
Judge, I'm going to answer your question directly and in a minute, if I may. But the first thing is, I'm at something of an impasse. I'm here as an adversary, always as an adversary in our adversary proceeding, and I'm also here certainly to serve this court and the people of our state. I heard what I characterize as a very narrow argument on specificity, the question of can we equate hydration, which I urge this court to address, with respiration, which the Hastings study and so on equates. I urge this court to go on to those things because the people of this state obviously, and that's why this is here, cry out for that direction from this court. I do urge you, we had a very significantly narrow talk about what you've got to delineate. I greet it with some degree of consternation. I equate with the greatest of respect, some of the questions from this bench with some of the questions from the bench in the Second Department, such as if you mean, from the Second Department at the oral argument, quote, if you mean that, do you mean that if this woman makes a living will today, a person makes a living will today and survives for 10 years, that, and a new machine is invented? That's just what I heard here in other language exactly. I'll address that. I asked the court to go a little broader.
Isn't that more a legislative function?
It's a legislative function when they speak. Obviously, Judge Kaye, they have not spoken, and that's why we are here. That's why we're here on a motion which was practically invited, and that's not by any means any kind of criticism. It was, I believe, I interpret as being invited by the Second Department because no one went up in the DeLeo case. They haven't spoken, and we need some guidelines, but we have some very firm guidelines in Stora, in Eichner. We have it in matter of ULO at 63 New York 2nd, that there is no 63 New York 2nd in 1986 from this court. Under existing, at page 357, under existing law, third parties are without authority to determine on behalf of the terminally ill that they should be permitted to die. That is the bottom paragraph under the paragraph giving voice again to the 1981 decision in this court of matter of Stora and Eichner. What we need here is the simple question that was asked by one of the judges in the Second Department. We need an answer to that. If, in fact, there is proof of by clear and convincing evidence, and that's our safeguard, and that's what this court set down in Stora and Eichner. And Stora, by implication, Stora was a walking, talking person. Far more, if you would, than Mary O'Connor is in her pitiful circumstances where she cannot recognize her children. Her own children she cannot recognize, much less answer the question that was not put to her in the transcript. The judge, the court inquired, Judge Colabella inquired to Dr. Sivak. Did you ask her whether she... I didn't ask her. Why didn't you ask her? Because she could not answer the question. I hope that answers one of the questions posed before I got up. Your question, Judge Wachtler, as to what was said and its specificity, on page 17 of my brief, we set some of it out, and your question, Judge Kay, answer by Helen Hall, one of the daughters. My mother said that she was very glad to be home. This was in 1984. Very glad to be out of the hospital and hoped she would never have to be back in one again and would never want any sort of intervention, any sort of life support systems to maintain or prolong her life. If she can't take care of herself, she can't be independent like she has been all her life. She does not want to continue to live. She went on to say, I'm sorry, but that's because the witness broke down at that point. Going down to the bottom of page 17 of my brief, which refers specifically to the pages in the transcript, gives chapter and verse on that. In Christmas of '85, answer by Helen Hall, she said in the event she became ill and unable to care for herself, that she did not want any type of life support or life-sustaining system. Now, what she meant by that? Answer, you don't know. Question, you don't know. Answer, I can't interpret for her. Now, that's an honest answer. Incidentally, everything in this transcript, beyond being beyond the pale of review on a factual basis by this court.
Seems to me that there are at least two components to the specificity requirement. One would be specificity with respect to the type of life support, and the other would be specificity pertaining to the particular conditions